law and the FLSA, or the Federal Fair Labor Standards Act. Thirdly, about how key it is to understand the basics of regular rate and computation of overtime in order to obtain compliance. And fourth, to talk about some of the trickiness of the exemptions that we're going to be dealing with. The reason we have entitled it to say that it can be expensive if you do not understand some of these issues is that non-compliance will often lead to DOL and state investigations and ensuing damages. And it's also possible that if DOL does not come in for an investigation, you're going to face lawsuits with appropriate damages, including attorney's fees. So misunderstandings can result in payments of lots of money as damages. So let's get started, first of all, with the issue of coverage. Coverage depends upon both the FLSA and state law. And I would remind you that if you are operating in a variety of states, you need to be doing not only a dual analysis, but an analysis that includes federal law and any state in which you are operating to find out what basically the highest requirement is for you to operate. Under the FLSA federal law, you have both enterprise coverage and you have individual coverage. Under state laws, you have a variety of coverages. For example, in Pennsylvania, the Pennsylvania law started as a little FLSA. That is a law that applied only to those folks who were not within enterprises covered by the federal law. Over the years, it has morphed into dual coverage so that you have coverage of most entities under both federal and state law. And in some states, you have some combination of these different types of coverages. Coverage, of course, goes with an employment relationship. We're not talking about bona fide independent contractors. We are talking about employees. If the enterprise is covered or if the individual is covered. Enterprises will generally be covered if they have an annual dollar volume of sales of $500,000 or more, which in this day and age is not a huge threshold, or if they are entities of a certain type like hospitals, schools, government agencies, and many medical and nursing home facilities. However, even if your organization is not one of those, there may be individual coverage. And the individual coverage comes about when an individual person is involved in interstate commerce. So that under individual coverage, you may have full-time domestic service employees and domestic service workers, babysitters even, and often the individual coverage will be what applies to some nonprofit operations, even if the nonprofit is not an enterprise under the enterprise test. So coverage is key, but coverage is widely applied either under federal law or state law. The second issue I want to talk to you about briefly is that state law often differs from the Federal Fair Labor Standards Act. And the starting point under this is to remember that state law can trump or top federal law, the Federal Fair Labor Standards Act. The test is that the law more favorable to an employee applies. So those of you who are in California, some of those of you who may be out in the Oregon area know that stricter requirements like you may have out there are going to apply even if not required by federal law. Additionally, over 1/2 of the states currently have minimum wages that are higher than FLSA. Conversely, there are 5 states out there who have absolutely no minimum wage. So if you're in Alabama, Mississippi, Louisiana, Georgia, or South Carolina, your requirement is to comply with the Federal Fair Labor Standards Act, and you do not have to worry about state minimum wage requirements. I use Pennsylvania often as an example. The Pennsylvania Minimum Wage Act applies to a number of Pennsylvania employers. Again, it started as a little Federal Fair Labor Standards Act. It has now morphed into major provisions which parallel the federal FLSA. However, there are important differences, and the courts recently in Pennsylvania have been taking the position that Pennsylvania law and regs amount to some 30 pages or so, whereas federal law and regs are hundreds and hundreds of pages. The courts are reading huge differences into the difference in the number of pages, the difference in the number of words, and in certain cases are saying that the federal clearly allows something, whereas Pennsylvania law is silent. Sometimes they are concluding that the silence means that it is not allowed under Pennsylvania law. So that's something that you have to be aware of, and that's not only Pennsylvania, but any state in which you are operating. The significance for me is that there are certain legal activities under the federal law which may be illegal under Pennsylvania law. I call it being clean under federal law and being dirty under state law. And that can happen in virtually any state that has a minimum wage law or minimum wage an hour requirement. We'll talk about just a few of the differences just to give you some idea. For example, Pennsylvania does not have a computer professional exemption. Pennsylvania also does not have the highly paid compensation exemption, which we're used to seeing now under the federal white-collar exemption. Our salary level in Pennsylvania is in the $250 or up range weekly, as opposed to the federal range of $455. So we want to avoid compliance problems with state law and non-compliance with federal, or vice versa. In Pennsylvania right now, the fluctuating work week has been viewed as problematic and may be something that is going to be tested in our courts. And the weighted average for overtime has become problematic as well. And that's just a difference in the way that overtime would be computed if you had an employee who was doing two different types of work at two different payment levels. Let's move now into issue 3, which is the need to understand the basics of regular rate and overtime calculation as a key to compliance. And you will see that some of these slides have differed because I've been doing some presentations with some of the folks out of the U.S. Department of Labor's Wage and Hour Administration, and they have some wonderful slides that we have included in portions in this presentation. You'll also see the straight Scarlatus and Zonderich slides as well. But some of these slides are so good that it makes no sense to reinvent the wheel. Under minimum wage basics, of course, you're talking covered employees, you're talking non-exempt employees, must be paid not less than the federal minimum wage for all hours worked. And I emphasize for all hours worked. That minimum wage is $7.25 per hour, and that's been in effect since July 24th of 2009. That amount must be cash or equivalent, and it must be free and clear. So there are cases in which employers have gotten into problems because they have made deductions from the minimum wage rate that has been specified. And that deduction, since it means the amount is not cash or equivalent, free and clear, has been enough to place folks under the minimum wage. There was a recent enforcement action in Pennsylvania by the Federal Department of Labor for an employer who was paying a full dollar under the required minimum wage rate. And of course, that affected not only minimum wage, but also overtime calculations. There have been a couple of recent executive orders that you should also be aware of. The minimum wage rate for federal contractors is now $10.15 per hour. Pennsylvania has also adopted a $10.15 per hour minimum wage rate under executive order for Pennsylvania contractors and a limited number of state employees. Some states have increased their minimum wages in excess of the federal minimum wage rate, and I will call your attention to a nicely done website by the Department of Labor, and the website is given there for you, which details some of the minimum wage and key provisions for some state laws in jurisdictions across the country. You should also be aware, especially if you are on the West Coast and even some East Coast cities, sometimes we'll have higher minimum wages by ordinance for a variety of employees. And let me stop for just a moment. Alex, if you're still there, will you mute your side of the line, please?
Of course. Hold on one second.
Okay, folks, are you still hearing me?
Kathy, I just got a response from them in the questions, and they can still hear you, so I'm going to mute myself again.
Okay, thank you.
No problem.
Bear with me, folks. Okay, we're back to the slide that I want to be back to, which is this compensation includes wages, so it's going to include any type of payment, salary, hourly, piece rate. It's going to include commissions, certain bonuses. It's going to include tip credits, and you'll see the tip that is the amount that is required for tips for federal employees. Again, that's something that changes in Pennsylvania and in some other states, and it can include the reasonable cost of room and board or other facilities provided by the employer for the employee's benefit. I will tell you, however, that I have not seen a lot of that lately. Regular rate is determined by dividing your total earnings in a work week by the total number of hours worked in a work week, and that includes non-exempt salaried employees. So if you compute the regular rate wrong, you're going to have problems all the way throughout. And we have a tendency, I think, to confuse things like regular rate with hourly rate. The regular rate often is higher than an hourly rate for an employee. So you want to be very careful about doing this computation. It, of course, may not be less than the applicable minimum wage under federal law or in the state in which the employee is operating. And that regular rate slide is probably the key slide to this entire presentation. The minimum wage example that is given just runs you through an employee who's receiving $9 per hour for 40 hours in a week. And that's a very simple computation. But they are also receiving, that employee also receives $5 in commission and $20 in reasonable costs of boarding, lodging, or other facilities. So in order to arrive at the regular rate will not be $9 an hour, but it will be $9.63 an hour. That is the $3.85 divided by 40. The $3.85 will include the $9 per hour for the 40 hours work, plus the $5 additional in commission, plus the $20 additional from room and board. So obviously that is higher than the $9 hourly rate that is specified. The next example runs you through a similar sort of calculation where you have an employee at $9 an hour who works 48 hours total, but also receives a bonus of $10, so that you can see that the calculation is 48 hours times $9 an hour, which takes you to $432 in compensation, plus the bonus of $10, which takes you to $442. The 442 is then divided by 48, which is the total number of hours worked. And DOL likes to calculate not on a time and a half basis, but rather on a half-time basis for overtime purposes. So they're taking 0.5 times 921 an hour, coming up with an additional 461 that is required. And then the 461 is multiplied by the 8 hours to come up with the overtime due. So again, just some examples that I think can be helpful to you to return to and look at from time to time. Deductions will often cause you problems under wage and hour law. If the deduction is for an item considered primarily for the benefit or convenience of the employer, and the deduction reduces the employee's earnings below the required minimum wage, and we could say minimum wage and overtime, that becomes a problem. We often see it in the areas of tools used for work. We sometimes see it in terms of cash register shortages or damages to an employer's property. Sometimes additionally, we'll see it with regard to uniforms provided or dry cleaning or laundering of those uniforms. So again, there can be no deductions made for those sorts of things. We also have some slides on tipped employees, and this is where the employee works in an occupation in which he or she customarily receives tips of more than $30 per month. It has to be paid under federal law. The employee has to be paid at least $213 in cash by the employer, and the employer may then claim a tip credit for the remainder of the minimum wage. However, under Pennsylvania law, this is an area where we differ, and we require a cash wage of $283, and then differential may be made up under the applicable minimum wage up for the remaining amounts. So you have to look at those, and those can vary a lot in a variety of different states because different states have different requirements. Employers are allowed to claim tip credits only if the employees know about it, and the employer can document these things, and all tips are retained by the employees and not shared with other employees. I will mention that the tip credit has come under scrutiny recently, and there is a very recent 10th Circuit case in which an employer was not claiming the tip credit, but was keeping tips and not distributing them to the employees at all. In that particular case, the 10th Circuit, which is out in the Oklahoma, Kansas, New Mexico, Colorado, Wyoming, Utah area, said that the employer need not share the tips with the employees. I suspect that those tips were pretty sizable for the employer to have made that decision. But there are cases in which tip credits are coming under scrutiny, and this was a case in which the regulation had indicated that the amounts had to be shared under federal law, even if the employer did not claim the tip credit. The next slide is a calculation for the Pennsylvania tipped employee credit. And again, you'll see the $7.25 minimum wage times time and a half. You'll see that you can deduct the tip credit, and you'll see the regular rate computation as well. And this is just to walk you through that in case you would like to see an example. Okay, this takes us into the fourth area of our presentation, which is that the exemptions in and of themselves are tricky. I would certainly recommend that you take a preview of the Act to decide if you believe that there are exemptions or exceptions from minimum wage and overtime that could apply to the employer for whom you are working. I would also caution you that in the wage and hour area, there are many definitions, many cases that have been reviewed by the courts, so there's a fair amount of case law. This is the type of area that I would always recommend that you discuss not only with an attorney, but an attorney who has worked in wage and hour law, because there are definitions within definitions, and sometimes your first read of these areas is an incorrect read as a result of all these definitions within definitions and case law interpretations. There are exemptions, and some states have exemptions as well from everything that is both minimum wage and overtime. There are also some industries which are exempt only from overtime. And of course, there are the white collar positions which have been receiving a lot of press recently. And again, variations may exist between federal law and state law. I know after having worked with Pennsylvania law for a number of years that we have a number of differences, even where it looks like the two may be the same on the surface. The white collar exemptions that are most common for FLSA purposes are often called the 541 exemptions, because that's the area that they appear in the Code of Federal Regulations, 29 CFR, and you start at 541. And then there are a number of regulations thereafter. We're talking about executive employees generally. We're talking about administrative employees. We're talking about professional employees. We're often talking about outside sales employees and computer employees. And again, the big ones in these areas are the executive, the administrative, and the professional. Generally, to the white collar exempt, an employee has to meet the requirements of a duties test as well as the requirements of a salary test. The salary test basic is that the person receives a predetermined amount of compensation each pay period on a weekly or less frequent basis, and that predetermined amount does not vary. The compensation cannot be reduced because of variations in the quantity and quality of the work performed. It must be paid for the full week in any week in which the employee performs any work, unless, I will add, that there's an absence based upon their own desires for a full day or more. And the salary need not be paid for any work week in which no work is performed by the employee. Highly compensated white-collar employees, right now the threshold for federal law is $100,000. It was to be increased to $134,004 on December 1 of 2016, and most of you are familiar, I'm sure, with the controversy around those regulations. There was also an injunction in the Fifth Circuit in Texas, which was applied nationwide, a preliminary injunction, so that that particular change, as well as the other changes for white-collar employees, did not take effect. There is no Pennsylvania equivalent of this $100,000 test. And what happened under federal law was that if you made $100,000, then the duties test was somewhat abbreviated. I think the feeling was that if you were making $100,000 or more, you were capable of doing your own negotiating with your employer, and basically DOL didn't have to worry as much. You weren't a minimum wage restaurant employee, for example, who might have had a hard time negotiating more with an employer. So at the $100,000 level, you had a less stringent duties test used by DOL, which DOL referred to as the relaxed duties test. Executive duties had to include a primary duty of management of an enterprise or of a customarily recognized department or subdivision. The person had to customarily and regularly direct the work of 2 or more other employees, and that actually worked out to be 80 hours of work in a work week. So it could have been 2 or more, it could have been many more employees, as long as it came up to 80 hours in a work week. And the person who was considered the executive had to have the authority to hire or fire other employees, or, as we used to say under labor law, had to be able to effectively recommend the same type of discipline or hiring or firing. There was also an exemption for an owner who had a 20% ownership, which, if you think about it, probably makes a lot of sense. That person who's going into business for themselves may not expect to really take anything out of the business for a significant period of time while they get the business on its feet. So that was the first, was the executive test, and I found that generally, if you took kind of a ruler and went across the organizational chart, you could often come up with some idea of where the executives existed and then where the folks that were not executive existed. The second big white collar exemption was the administrative exemption, and there an employee had to be able to perform administrative duties. This one to me has always been kind of the soft underbelly of the exemptions, if you will. It's harder to understand. It's harder to predict in terms of what DOL will do with it. And as a result, it is an area which is often under constant scrutiny. So if you can pair the administrative exemption with another exemption, I always like to do it so you have 2 shots at the exemption world rather than just one. However, sometimes that can happen and sometimes it cannot. The primary duty of this person has to be related to management or general business operations of an employer or the employer's customer. And it has to have a primary duty, which includes the exercise of discretion and independent judgment. Many times it will fall apart because the administrative person will not really have authority to exercise their own discretion and independent judgment, and that becomes a real problem. And one of the things that DOL is, or any state administrative enforcement body on wage and hour will look at. We want to talk about some of the things that are included in management or general business operations, and I'd like to give you a visual other than the one that is on the screen right now. For me, one of the things that has always made a lot of sense is if you go back to the old movies, even the black and white genre, but even some of the more recent ones, where you had a factory floor, you also generally had a set of stairs on the right-hand side of the screen. That set of stairs led upstairs to some pretty, at that point, rickety-looking offices for executives and other folks that were included within the management or general business operations of the company. And often that housed the accountant or the CFO, the personnel manager, which has now morphed into the HR office, and a variety of other things, including some of the things that are on your screen right here. Then you had, if you're going to the movies like Norma Ray, the production floor in which the people were making, the factory workers were making whatever that particular business made. By and large, the people upstairs, many of them at least, were within the administrative exemption. Not everyone, because obviously you had some clerical staff up there in addition to the people that were making the decisions. But by and large, the offices upstairs were housing your folks who were either professional or within the administrative exemption. So if you think of these categories and you think of the old movies at the same time, I think it makes it easier to understand the administrative exemption. The final of the three white-collar exemptions that is really important, of course, is the professional exemption. Professional duties, however, are not always what the layperson would think they are. And I know this becomes a morale area for some folks because people don't want to be considered anything but professional in their job. You could have a plumber, however, who is definitely a blue-collar manual worker who is very professional in the way that he or she performs the work. So you cannot confuse the varying usages of that term. For professionals under wage and hour law, the primary duty is the performance of work requiring knowledge of an advanced type. I believe you should read knowledge of an advanced type as a 4-year degree. This would be in a field of science or learning customarily acquired by a prolonged course of study or specialized intellectual instruction. So if you think of an accountant, they will probably fall within that 4-year, at least an accountant who is registered with one of the various state licensing boards. If you consider certain people within the environmental area, they will also have 4-year undergrad degrees that are required. The primary duty of these folks has to be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. And if you will, put a pin in the or talent in a recognized field of artistic or creative endeavor, and we'll go back to that in a moment. The fields of science or learning, again, law, technology, medicine, pharmacy, accounting, architecture, engineering, you see a whole bunch that are listed on this DOL slide. These are commonly exempt professions. Chefs may be exempt if they basically have the authority within the kitchen and they are clearly trained. This is an area that leads to a little bit of controversy because some folks are dubbed as chefs when they do not have particular training. I always add the certified or the licensed athletic trainers. I have relatives, I have daughters who are athletic trainers, and that is now a 4-year undergrad degree, and those folks are really physician extenders who both prep athletes not to become injured and also deal with injuries after the fact. So you will see a number of these things that are commonly considered as exempt professionals and were dubbed as such in the most recent set of adopted regulations. However, there are also many folks who are not exempt professionals. That would include your LPNs, that would include your certified nurses assistants who had something like 10 to 18 weeks of training. That would include accounting clerks and bookkeepers who do the normal, more routine work without the independent judgment. It includes paralegals and legal assistants, which is often something that surprises law firms that don't work in this area. And it includes many of your administrative assistants. I will not say all, because I have seen case law in which administrative assistants who are really gatekeepers for the CEO have been treated more as administrative employees rather than as professional employees and have passed wage and hour muster. But your general administrative assistant will probably be non-exempt. I asked you to put a pin in the idea of the recognized field of artistic or creative endeavor. There we're talking mostly about musicians, we're talking about writers, we're talking about actors and performers, we're talking about certain of the graphic arts people. We're probably not talking about reporters who simply report the news, because there is less involvement with creative or artistic endeavor. In short, it seems to me that nobody is too worried that Cher will receive at least the equivalent of minimum wage or overtime, because she is quite capable of demanding salary on her own, or other folks in that kind of a category. So that is the flip side of your professional exemption. It is either the erudite type, if you will, or it could be the ballerina, if you will. Okay, for any of these white-collar exemptions that I've just talked about, we're talking about a minimum salary level in effect right now of $4.55 an hour. And stay tuned, because we'll talk a little bit more later about the proposed regulations. The enjoined regulations would have increased this salary threshold to $9.13 a week. They would have allowed 10% of that amount to be derived from commissions or bonuses, and they would have continued to increase the salary amount on a 3-year basis with an automatic escalator, with a COLA, if you will. You will remember that these were the regulations that were due to go into effect on December 1st, and then the court entered a preliminary injunction. There was a difference for educational employees. The 47,746 threshold was not applied. Instead, they would have used a salary level tied to a starting teacher or starting professor. I'm sure that that would have cut both ways, depending what was paid at a particular educational institution. But there was a little bit of an out for the educational institutions. Not that long ago, the Department of Labor, for the first time that I can remember in my legal practice, asked for what has been referred to as an RFI, or a request for information. That is still open right now, which means that if you want to make comments for your employer, for a local SHRM chapter, for some group that you are affiliated with, or for yourself, that you could enter comments as a result of this request for information until that time. The RFI has identified a number of issues with regard to white-collar exemptions, and says that the Department of Labor is specifically interested in obtaining commentary on some of these areas. If I may be permitted a personal opinion, these were areas that were put together by folks that do virtually nothing but wage and hour law. And they are not the sorts of things that I think most HR folks, or even most employment and labor attorneys, think about. The first one, an adjustment, one could argue that there should or should not be some sort of cost of living adjustment after some fixed period of time, and I'm sure we could have a lot of discussion about the appropriate period of time that should be used, and that's fine. They've also asked whether there should be multiple salary levels, so you could have a different salary level for a professional than you had for an administrative employee, than you had for an executive employee. So that starts, in my estimation, to complicate an already complicated area. Should they be tied to short and long tests, or something in between? Should there be a more relaxed duties test with the higher salary levels? And we've talked about the fact that DOL on its own has already somewhat done that for employees over $100,000 and to be in the 134,000 category. Should it eliminate the need for a duties test? Did employers increase salaries based on the proposed regulations? And frankly, I know many employers who were going to do that and did comply with the new proposed levels in advance of December 1st. I also know, for example, in the athletic training profession, that some employers did it or talked about doing it, and then when the regs were enjoined, reverted to the levels that had been in effect. So I think some employers complied early, some employers complied early and switched back, and some employers just waited. DOL wants to know whether there would be a duties test, whether that's better than a salary test. Did the salary test proposed preclude certain levels of previously exempt occupations? And again, I happen to know that for some of the athletic trainers, although they were dubbed as professionals in the regulations specifically, the salary level would have precluded numbers of them from being considered as professionals if the increased test went into effect. Should bonuses and discretionary payments be allowed to offset part of that required salary? Should there be multiple salary levels for highly compensated employees? Should it be again updated as a COLA along with some other updates perhaps in this entire area? So these were the areas that the RFI from the Department of Labor asked that we emphasize. However, before I go into any questions, I also want to go into a little bit about what seems to be happening right now. We talked about the preliminary injunction in the Fifth Circuit, the Texas federal court that was in place, and that is still in place. That whole thing was briefed by the various parties, including, I believe, the American Chamber of Commerce, a number of business groups, and a number of other groups. The Trump administration, however, does not wish to give up the authority for the Department of Labor to set a threshold on these white-collar exemptions. Having said that, they apparently believe that the threshold set by the last set of regulations was too high and should be reduced. That argument was briefed in front of the court. An oral argument is scheduled for October 3rd. You realize, no doubt, that October 3rd is not very long after the request for information is due on September 25th. It is possible, and I am not predicting, I am simply saying it is possible, that the court would remove the preliminary injunction. If the court does remove the preliminary injunction, the question will be when the proposed regulations, which were previously enjoined, will go into effect. I would expect it to take at least months before the Department of Labor can digest the comments that it receives as a result of the request for information. So we have some time frames here that may be a real issue and may catch many employers who thought that the regulations had gone away, the proposed regulations had gone away for good. It may catch some of those employers off guard. So this may be one of the areas that you want to discuss with your chief executives to see what they think they would like to do. Obviously, if you were one of the employers that implemented the proposed regs already, you have nothing to worry about. However, if you did not implement and the salary levels make a difference to you, you probably want to dust off that file that was put away and determine whether or not you can comply and whether or not you can comply quickly. I don't know if perhaps the court would give some gear up period. If the court does not, I would anticipate that perhaps DOL will give some gear up period before they begin enforcement, so that of the higher levels, so that folks do not have to comply immediately. However, I've been in legal practice long enough and worked with the state legislature as well. So both of those experiences let me know that you can never be sure what will happen in situations like these. So all of this is something that you should be thinking about in addition to your normal understanding of regular rate and overtime and the exemptions themselves, because if these proposed regulations go into effect, it could make a significant difference. Now, I want to talk for a moment about what we have not talked about by design. I have not talked to you about counting hours. And obviously, wage and hour law is really a math problem where you multiply the number of hours worked by the appropriate regular rate or overtime rate. If you are counting hours wrong, that becomes a problem. So, for example, Google Fiber texts are just on the receiving end of an arbitration award, which has been approved by a court, which is giving them some $1.28 million because they felt they were underpaid for work done before their regular starting time, for work done at lunchtime, and for work done when they had clocked out. The definition used for work is that the employer suffered or permitted the work, and I will frequently say that the employer in that case does the suffering, because if it is for the benefit of the employer, chances are it will be considered as work, will be considered as work within the wage and hour definition, and should be multiplied by the appropriate regular rate or overtime rate. I have seen audits in which investigators have added back lunch half hours just pretty routinely because employees were interrupted during lunch periods, did not have a full half hour to themselves, and therefore the time was added back in. And once that time was added back in, it threw them from the regular 40 hours in a week into an overtime situation. So the count of hours is definitely something else that has to be considered within wage and hour law, and that's the subject really for an entirely different seminar where we could talk more about it. I will mention to you that the Department of Labor has many fine fact sheets online. There is one for white-collar employees, fact sheet 17C, for example, talks about the administrative exemption, and I would certainly call that to your attention. For any of you that are in hurricane zone or affected by the hurricane, you might also want to know that there is a hurricane recovery fact sheet now on DOL's website, and I would call that to your attention. It visits multiple laws, so I think it could be a very, very helpful thing to you. And again, if you are in those areas, please draw distinctions between your hourly employees who need to be paid only for actual hours worked and your salaried employees who must be paid for all hours within a week if you were closed during that week, if they performed any work within the work week. If you were open and they did not appear, there is the possibility of deducting days for convenience to the employee. But do be aware of the distinction between your hourly employees and your bona fide exempt employees in those